Somebody's handed you a trust and told you that you're in charge now, you're probably wondering what to do. My name's Greg Nussbickel. I'm a estate trust and probate attorney, and I can give you an idea on where to start. So, first thing you're going to want to do, of course, is to get the trust agreement itself, look through it, read every page. I know it's probably a long 30, 40 page document sometimes, and try to figure out, are you the named individual that is in charge at this point because you're nominated as the successor trustee? Is there anybody else who might also be a co-trustee or what we call a trust protector? They can be involved sometimes with limited authority to affect things. Uh, the trust itself, if you're not familiar with those, is really just a contract. So this would be something where maybe a loved one set up a living trust during their lifetime. They were the trustee, also what we call the grantor, and now that they've passed, perhaps you're the trustee. So this is a voluntary thing. You're not required to be the trustee just because you've been nominated. But if you do decide to take the role on, there are a number of responsibilities, legal obligations, and liability that can come with that. So you just want to go in with your eyes open. You are also usually entitled to some kind of compensation for taking on that role. So that would usually be listed in the trust itself, or sometimes there's some fallback provisions in Florida law. But if you do become the trustee, you have notice requirements. So any qualified beneficiaries are entitled to know that you've accepted the role, usually within 60 days, or to be given a copy of the trust, also within 60 days. And if that's 60 days after the original grantor died, that's where you'd measure that from. And so, really that's kind of a baseline thing. You want to, make sure that everybody's aware of what's going on. Ultimately, you're going to be doing an accounting of the assets that came into the trust and the expenses that went out, and then a distribution plan at the end. But there are other things to keep in mind. There's what's called a notice of trust that you need to file if the grantor has died. That goes into the court records, and sometimes there's also a probate that comes along with this. There might have been a pour over will that decided that the trust is the beneficiary of the assets that were in the decedent's name. So it can be a little bit complicated, but your overall job is to manage the assets, to make sure that they're secure, not subject to a hurricane blowing through, some kind of damage to property or some loss. So if there are investments that are more risky, you might need to move those over to more conservative planning, that kind of thing. Deal with tax implications. So for the trust itself might owe some kind of taxes. The decedent may have income taxes or estate taxes that they need to deal with. So a lot of times you'll be on point for that. And you really just want to make sure you have all your ducks in a row before you start handing out distributions, because you may have a hard time getting those back if there are some debts or other obligations that weren't covered. Um, Oftentimes, as you can tell, this is a little more complicated than just a layperson who's not used to this type of thing can handle on their own. So you may want to think about calling a qualified trust and estate attorney to guide you along the way. And if you do need any help, of course, feel free to get in touch with us. Appreciate it.